This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about injuries. So that's everything from car accidents to medical mistakes, about filing a claim, about figuring out if you even have a claim. What if your insurance company offers you a nice quick settlement? Is that a danger signal? What if they have the exact opposite reaction though and they won't even return your call? What do? When do you need to talk to a lawyer first? All these kind of questions. If you've got a question, call in. The 31 Law Call number 256-536-0077. You can also email. You can email to lawcall@waytv.com any day of the week about any legal question. And when we get to a show that's on point, we'll pull some out. And we have some of your email questions coming in tonight, all about injuries. Getting us started tonight, we've got Michael Timberlake and Heath Brooks, and you guys have got a big announcement this week.
Yeah, I mean, normally you would say this is from Timberlake and League.
From Timberlake and League.
But from here on out, it will not be Timberlake and League. It will be Timberlake, League, and Brooks.
That's great. Congratulations.
I could not be more excited about this announcement. Really, it's, you know, long relationship, long professional relationship, great friendship, and I'm thrilled that we will now have to change our name and tell everybody that we're Timberlake, League, and Brooks.
That's right, and cool. I'm thrilled too. Same, it's been a long time, but different name, same great team.
Right.
How many years you been working with Timberlake and League?
I've been working for Timberlake and League for 15 years.
Right. Yeah. Much deserved. Much deserved. Timberlake, League, and Brooks. The signs are changing.
That's right.
Love it. Okay, we've got tonight's You Make the Law Call. We like to pull out a video off of YouTube, something that it's a traffic accident, a personal injury case. This guy is in the tractor and he's backing up. He's clearly going the wrong way, but it looks like the street's all clear and it seems like it's going to be fine. Well, hold on. No, it's not going to be fine because a tractor-trailer truck is coming. Now, everybody was okay after this accident, but something like that you guys see injury cases, wrecks, things like this all day, every day.
Right.
What do you see if this had been in Alabama?
Well, first thing I looked at the video, I'm thinking it's in reverse.
Yep.
You know, and it's not backed up, but the big yellow truck's coming that way. So, you know, I don't think this is a case about ordinary negligence that we would consider. I think the question is, you know, whether what this guy did was reckless.
Yeah, you know, you don't really want to back up a one-way. That's just not a good idea. Of course, the thing is that as a truck driver, tractor-trailer driver on the road, you also got to watch out for crazy things. I mean, you can't just hit somebody if you can avoid them. But somebody going the wrong way on a one-way, backing up, there's absolutely no way they can know what kind of traffic is coming in a tractor, moving that slowly. It looks like traffic is moving quickly.
Yeah.
It's an issue.
Yeah.
And you know, that's on the tractor-trailer.
Those big trucks, they weigh a lot. Right?
Yeah,
it's like almost like a train.
You know, you've got a situation where it's kind of like, you know, in a situation in Alabama where, you know, if you're, you know, pull out in front of a train, the train has the right of way. And that's clearly what we've got a situation here. You've got a big truck, you've got somebody that's moving through, you know, town, and they've got the right of way, and you just can't back your tractor right out in front of them.
No.
It just doesn't work that way.
And how do you not see a big tractor-trailer coming down the road either?
Why are you driving a tractor backward on a main road? It just doesn't make good sense.
All's bad.
All bad.
Right.
We've got callers waiting. Is it Cheryl on the line with a question from Scottsboro? Hi, thanks for calling. What's your question tonight?
Yes, two people that I know have been living together for 8 years as a couple, and she passed away. And now the kids are asking him to leave the home, then saying that he has to leave the house because the house was in her name. And, you know, she says, like, if the house is in probate or whatever, and there's no lease, he has to leave. But he's been living there with her for 8 years and paying bills and, you know, supporting her. So we wanted to know what the rights would be.
Yeah.
Yeah, I mean, you know, and that's a legitimate, you know, question that you want to have, and especially somebody when it passes away, you know, what are the assets that are in that person's estate? And the first thing you look for is real estate. When someone, you know, is there any real estate? Is their house in their name? And if the house is solely in his name and not in his girlfriend, tenant, potential common law wife's name, then the heirs of the estate or whoever takes over the estate, the personal representative, is going to want to secure the house. And they can't ask anybody that's not designated as an heir to leave the house. Now the question is this somebody that could claim to be a common law husband or something like that?
Family law, the state of Alabama used to regularly have common law marriage. So it's not particularly a question of length of time that they've lived together, but it would be, did they hold themselves out to be married? Would people assume them to be married? Did they file taxes together claiming to be married? But even the state of Alabama got rid of common law marriage a couple of years ago. So unless you were grandfathered in, having established that relationship before the law changed, you can't even claim it now. So it's something to look into, but it's a challenge to establish. And with something like this, if the property wasn't changed over, I think it's going to be a real difficulty to claim that.
But for somebody that's living in a house lawfully, you can't just tell them, we own the house now, you got to get out, right?
No, you can be a tenant.
Yeah.
That's another thing. You can be a tenant under the state of Alabama's law, and then you can be a month-to-month tenancy. I mean, and then you have to go through the proper procedures, what's called an unlawful detainer, go to the court, ask the court to issue an order for the sheriff to remove you from the house, and it can be a lengthy process. And you can actually, you as the person who does not want to leave the property can actually fight it. And if there were some improvements made to the property that could be demonstrated to be out of that individual's pocket, there could be an argument that you could get some money back out of any kind of a sale. So there are some issues you could deal with there, but ultimately, if the house is not in your name, the real estate, the land is not in your name, and the person who's living there passed away, it's going to be a tough road to plow.
Yeah, but judges are going to say you could have done something about this, right?
Right, absolutely. And they're going to say you should, if you were married, you would have been married. Or if it was wanted a house in both your names, you could have put it in both your names.
Or leave it in a will.
Yeah, right. But you can't just walk in there overnight and kick them out. You got to go through the proper process.
You got to go through the proper process.
We've got some email questions. We got this email question. This one is from Ted. Ted had written in, is there a time limit for when a person can sue another property owner for injuries that occurred while working on the person's property? Okay, what are we talking? Is it statute of limitations, or does it matter?
Well, I'm going to take the easy part of this question. So basically, in Alabama, if you're injured in any way, shape, or form, or God forbid that somebody dies, you have 2 years to file a lawsuit, basically to prove your case in a court of law. It doesn't mean you can't settle it after that point, but you still have 2 years before you have to file a complaint, and that's not just talking to an insurance company or talking to somebody about your issue. You have to have a lawyer, have to file that in court. If you don't file that within 2 years, then you're going to be out of luck. There's some very limited exclusions, but that's basically the thing. But at the same time, if you're injured on somebody else's property and you're working, what's the story there?
You could. You're not going to get a workers' compensation claim out of that, because generally the guy who owns a piece of property is not going to have workers' compensation insurance. But that homeowner may have a responsibility to provide a safe work environment. That doesn't necessarily mean you don't get over the 2 years time limit. But with the ability to file an action for, say, a homeowner who had an open well didn't tell you about. That's an unsafe work environment. Or a porch with a board that wasn't properly nailed down that caused you an injury while you're working on that property. That's an unsafe work environment. So there are some options that you could have if that homeowner is not providing a safe environment. If you create the hazard, though, if you are the one who puts the ladder up and then fall on your own ladder, you're not going to have a claim there. It is something that the homeowner would have to have been negligent about to cause you an injury, and then you may have a claim. But 2 years. 1 year in Tennessee.
What if you're up on a ladder and a homeowner knocks the ladder over?
We may have seen that before. We may have seen that before.
It could have happened.
Could have happened before in 2 years.
2 years.
You got 2 years.
Okay.
1 year in Tennessee.
We're going to take a break. We'll be right back answering more of your questions. Everything from what are trials like, how many times are cases actually going to trial? Do most of them settle? Calling your questions, the 31 Law Call number 536-0077.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. How about that? Timberlake, League, and Brooks. Very nice. Congratulations.
I had to practice, and you did good.
We've been working on it, getting ready, getting practiced up.
I've had to practice on the phone.
Have you? Everybody's got to get used to it. Timberlake, League, and Brooks.
Yeah.
Timberlake, League, and Brooks.
Yeah.
We are talking all about injuries, and that's what these guys do, personal injury cases. So that's everything from car accidents, medical malpractice, pharmacy errors.
Products liability, all kinds of
liability.
You know, whatever. If somebody else has harmed you in some way, we want to talk to you about it. We'll see if we can help.
Okay. We've got callers waiting. We've got Johnny on the line with a question from Florence. Hi, Johnny. Thanks for calling. What's your question tonight?
Good evening.
Good evening.
My question is, with all this weather we've had and rain, I've got a little bit of a roof leak, and I was fixing to hire somebody, maybe just out of the free paper or something. And if they get up there and on that roof and fall off and hurt themselves, am I going to be liable? Or do I have to press them to make sure they got insurance before they get up there?
Good question.
Well, Johnny, there's two things here. First off, when you hire somebody to do work on your property, make sure they're licensed and they're insured. You know, whether that's insurance to protect you in case that they cause damage to your house or don't do it right, or hurt something else on your property that they didn't intend to, but make sure that they're properly licensed by the state of Alabama. That's to protect yourself. But specifically in answer to your question, if somebody that is a roofer gets up on a roof and injures themselves while they're doing their job on a roof, that's on them. Most likely that is not going to be on you. The difference is that if there is something else on your property, and the example I gave, and it's been used for 150 years probably, is that say you have an old well on your property that's been covered over with boards, and only you know about it, nobody else does. And this roofer's walking around the yard to go get a piece of equipment or put something in a pile and falls in your well, then you may be responsible for the injury in that kind of scenario. But the roofer being up on your roof, falling off the roof because they weren't doing their job appropriately, that's on them. That's not going to be on you. But make sure they're licensed and insured for sure.
Yeah, and especially if you're dealing with somebody that deals with tree service or something like that that could cause significant harm to your property. You know, you want to make sure that you hire somebody to cut down a tree and it comes on your house. They're not just going to be able to walk away from it. That they're going to have somebody to back them up and help you solve the problem.
We've got Kevin on the line with a question from Huntsville. Hi, Kevin. Thanks for calling. What's your question tonight?
Hi there. My friend was in an accident while she was texting.
Okay.
And can her insurance refuse to pay her claim because of that?
Was she driving, or what? Is that the situation?
Yes, she was driving, yes.
Okay. Texting. Can they refuse to cover you if you were texting while and caused the accident?
Typically, liability insurance will cover you for anything that you do while you're operating a vehicle, and if you do it in an unreasonable fashion. So, the question you've got is whether there is some exclusion in the policy that would cover somebody that was doing something for distracted driving or texting. To my knowledge, there's no specific exclusion that I've seen that would cover this situation. But if you're doing something that would deem to be reckless or potentially in violation of the law, which is now the case in Huntsville, the policy exclusions do extend that far.
That's true. There's a type of damages in the state of Alabama. It's called punitive damages, and those damages are meant to keep somebody from doing that conduct again, to deter that conduct. There are some insurance policies that will exclude damages of a punitive nature, punitive damages. So what that means is that if you get all the way to a jury trial, or maybe even if you're arguing with an insurance company, but more frequently when you get to a jury trial and a jury awards punitive damages, then your insurance company, if there's an exclusion for punitive damages, may not cover you. And that's important for you to know about.
Take a look at the policy.
Yeah,
you'd
have to look at it, but it's obviously you can have coverage for, having a motor vehicle wreck while you're intoxicated. And even though that's illegal and it's a criminal act, it doesn't mean you're not going to have coverage. I think that texting is going to be seen in a similar light to that, but it's going to be insurance company to insurance company and policy to policy.
We've got Paula on the line from Morgan County. Hi, Paula. Thanks for calling. What's your question tonight? Hey, Paula, are you with us? Paula from Morgan County. Okay, so I know the gist of Paula from Morgan County had a question about a dog, and I didn't hear the full. Neighbors have dogs that bite. Okay, and we were just talking about dog
Sure.
and some things a little different in Tennessee, but dangerous dogs. Talk about that.
Yeah.
Yeah, I mean, in Alabama, basically, a lot of it depends upon who you are. You're the dog owner.
Okay.
You're the dog homeowner, or you're a homeowner where the dog lives, or you're a landlord where a dangerous dog lives. But typically, there's very limited liability for anybody other than a dog owner that knew or should have known that that dog was dangerous in
So
some
if it's
way.
a surprise, then there's.
I mean, if you're your cockapoo reaches
Corgi
out
dog,
and
my corgi dog.
is at work and reaches out and bites somebody,
Okay.
and just surprisingly,
Yeah.
that's more than likely not going to be an issue.
Okay.
But if your dog is known to be dangerous,
Did it before.
or under the law has dangerous propensities, then you can have a problem. And what does that mean?
You know, the state of Alabama, it takes an old school look at the law. A lot of states have moved away from this, but Alabama has you got one chance, dog. You got a one bite rule. You bite once, and then it's a get out of jail free. The owner of the dog most of the time is not going to be responsible if there are injuries. But if the dog has bitten somebody before, or has attacked another animal, or has exhibited a dangerous tendency towards aggression, then what can happen is the next time the owner of the dog can be responsible if that dog hurts somebody. The one exception to that is the pit bull breed. In the state of Alabama, a pit bull is considered a dangerous breed of dog, and there is no one bite get out of jail free card. That's just if a pit bull terrier bites somebody, the owner is going to be responsible if that pit bull bites. Now, one thing to know about, a lot of homeowners insurance policies, which is typically the type of policy that will protect a homeowner and an owner away from a dog biting somebody else, will exclude certain breeds of dogs like pit bull from coverage. So what that means is if your pit bull goes out and bites somebody and they make a claim against your homeowner's insurance policy, your coverage may not cover you. So that is something that you really need to pay careful attention to in a homeowner's insurance policy. There is also one more thing we mentioned earlier. The state of Alabama has a newer trend in the law where the landlord can actually now be responsible if their tenant's dog bites someone else and they know that tenant's dog is dangerous. That's the key. They have to know. The landlord has to know that dog is dangerous and has dangerous tendencies.
Yeah.
Okay, let's.
There's a lot to say about dogs.
Okay, we got something else to say about dogs.
Sure.
All right, let's take something different. Let's talk about your pet being injured, like from another dog. If your pet is attacked and injured, can you sue about that? What about if you see it? Can you bring a lawsuit? I mean, that's very traumatic if you see your dog killed, because
Sure.
you hear from people all the time with injuries.
Yeah, I mean, honestly, we get a lot of people that contact us about that, and it's a sad situation, and we love pets. We all have pets, and when you lose a pet, it's a very sad event. But people will ask, will my neighbor intentionally, kill my dog, or a veterinary person, negligently did something, or what, would people consider to be reckless that would injure or, possibly kill a pet. And, we of course, we'll talk to them about that situation, but really in Alabama, the damages you can recover for the loss of a pet are limited to the value of the animal. And you don't get sentimental value, you don't get to, any kind of situation where, you get emotional distress as a result of that. You're limited to the fair market value of the animal. And in a lot of situations, that's fairly limited and would prohibit, being able to pursue any kind of legal action, because you would spend as much money chasing that rabbit as you would, potentially catch it. But, that's a situation we have. But in, other states, they have different laws.
That's right. And we were talking about this earlier. In Tennessee, you can actually get emotional damages if somebody else negligently kills your animal, your dog or your cat. It's limited to $5,000, and veterinarians and other officials are excluded from that law. But that is the trend in the United States, is moving towards allowing for emotional damages if somebody negligently kills your animal. Alabama doesn't allow for that. So, it's the value of the animal. If your dog you breed your dog, then you may have a higher claim. Or if you have a thoroughbred horse that races, you may have a higher claim. But most of the time, it's not really going to be worth going forward with the action.
We do love our pets. We're softies for our animals.
Absolutely. And so those are sad calls, I take.
They are. Let's talk a little bit about what trials are like and what percentage of your cases actually go to trial. If somebody's bringing a lawsuit, it's stressful and it's nerve-wracking getting ready for it. How many of them actually go to trial? How many of them settle out?
Well, a lot of it depends on what kind of case you're looking at.
Okay.
You have, motor vehicle wrecks, probably the most common personal injury case. Most of those cases are resolved. Probably 85–90% of those cases are resolved outside of court. You have workers' compensation claims. There's sometimes there are not a lot of issues to be decided there. Those cases can be resolved out of court a lot of times. Medical malpractice cases are exactly the opposite. Almost all of those cases are tried before a jury. Why? Because people that represent hospital and doctors or those defendants in those situations will try those cases, and most of the time they get a good result for their clients. So it's really kind of a matter of, what is the risk involved? What are the issues involved? What are we looking at? Sometimes cases can be thrown out before they ever get to a jury trial. Premises liability cases are kind of very common to that, or any case where you can say that somebody that was injured was at fault. So it really is a difficult decision, to say what's going to be tried and what's not going to be tried. The more common of a case it is, with a more clear liability, the more likely it's going to be resolved.
Always be prepared to go to trial, though.
Oh, absolutely.
Always be prepared to go to trial. You
and
never
don't
know
hire a lawyer that's not ready to go to court.
That's not going to go try the case.
You don't ever know when it's going to go to trial, no matter what the case.
Be right
That's
back.
why we were Timberlake, League, and Brooks, because he goes to court.
If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake and Heath Brooks with Timberlake, League, and Brooks in Huntsville. 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way. And I do family law, divorce, child custody, 256-539-7337. Also check out SharonFamilyLaw.com.
And she does a great job.
Thank you very much. Congratulations again.
Thanks a lot.
Timberlake, League, and Brooks. Thanks for all your questions tonight. We'll see you next week.
Good night.